Hello, George.
Hi, Ansam.
In this second episode, can you please tell us a little bit about the choice of forum and law and the procedural rules?
Sure. This podcast is probably the most important of all in this series of podcasts. Get this right, and it is easy to get it right, then your dispute won't become sidetracked over purely procedural issues. Get it wrong, and you might not even be able to bring your claim in arbitration. As we saw in the last episode, arbitration is consensual, and for New York Convention purposes, the agreement has to be in writing. The arbitration clause obviously needs to provide for arbitration, but ideally it should also contain three provisions. First, the governing law of the contract, and this will be the law the arbitrators apply to the dispute. Second, the forum or seat, which could be any of the main arbitration centers, such as New York, Singapore, Beijing, or in this case, we're talking about London. And thirdly, a set of procedural rules. You can even have a hybrid, for example, London arbitration with New York law or Singapore arbitration with English law, but problems can occur with these hybrids. As to the law, English law is very user-friendly. And for example, to evidence a fixture, the recap only is fine. You don't need an engrossed signed charter. The choice of seat is super important. If you don't provide which forum is in charge, no set of arbitrators can claim jurisdiction. There have been some really important cases recently where the English courts have grappled with this question of jurisdiction, where usually there is some monkey business going on. For example, Russian companies trying to avoid London arbitration agreements. Lastly, it's best to agree a set of procedural rules. Many jurisdictions have a statute or some form of codified provisions regarding arbitration, but one size does not generally fit all, and so specialized institutions have evolved their own terms. There are, for example, the terms of the institutions, such as the ICC and the LCIA. But as we're talking about London maritime arbitration, it's probably best to use the specialists, the ad hoc procedural rules from the LMAA. BIMCO, the industry body, has a series of recommended clauses and standard forms. They are huge supporters of London arbitration, and I recommend you look at their forms for the best examples of arbitration clauses, especially as they're continually reviewed and updated as the law evolves. But it is its simplest. As I've said, English law is very flexible, and as a minimum, the following words will work just fine: London arbitration, English law, LMAA terms.
Thanks so much, George. Bye-bye.
Bye-bye, Ansam.